folks, thanks for stopping by. My name is Greg Robinson, and today I would like to discuss with you the term digital assets. The term digital assets might be a term unfamiliar to many individuals, but it is becoming more important due to the changing environment of estate planning. There is no clear-cut definition of what constitutes a digital asset, but it can be loosely defined as any record which is electronic. In the last decade, advances in technology have completely changed the way we live our lives. We communicate through emails and text messages rather than phone calls or handwritten letters. We store our financial records online instead of in file cabinets. We keep our family photos and other items of intrinsic value on social media sites like Facebook, Twitter, and Instagram. Today's world is a digital one, and all of the above items constitute digital assets. The questions of how to protect your digital assets through the use of estate planning documents and protecting the privacy of your digital assets are now inextricably tied together. 2 U.S. federal statutes regulate much of what an executor can and cannot do with the decedent's assets. Those statutes are the Computer Fraud and Abuse Act and the Stored Communications Act. Additionally, the terms of service agreements of individual companies restrict executors and fiduciaries from being able to perform their duties. The first problem executors face is one raised by the Computer Fraud and Abuse Act, which fines or even imprisons anyone who intentionally accesses a computer without authorization or exceeds authorized access. The Computer Fraud and Abuse Act contains no specific provisions or exemptions for executors attempting to access a decedent's digital assets. As a consequence, it is foreseeable that using a decedent's computer could result in a well-meaning fiduciary being fined or possibly even imprisoned. The Stored Communications Act added new statutory provisions to protect the privacy of stored electronic communications, either before such a communication is transmitted to the recipient or if a copy of the message is kept after it is delivered. Attempting to subpoena records, which are protected by the Stored Communications Act, will not necessarily be successful. In the case, in re request for order requiring Facebook to produce documents and things, Facebook successfully quashed a subpoena which sought access to a deceased user's Facebook account. The deceased died after falling from the 12th floor of an apartment building in Manchester, England. Her executor, who believed that her death was not a suicide, wanted access to her Facebook account to try to obtain information regarding the deceased's actual state of mind in the days leading up to her death. The applicants in this case were trying to compel Facebook, through the use of a subpoena, to produce the records of the deceased account. The court denied them the power to do so, and the court stated, to rule otherwise would run afoul of the specific privacy interests that the Stored Communications Act seeks to protect. As the court pointed out, a civil action seeking to force the provider to disclose the records will not be successful under the Stored Communications Act. The court, however, looked for an exception under the Stored Communications Act, which would allow Facebook to voluntarily disclose the records. The court stated, under the plain language of the Stored Communications Act, while consent may permit production by a provider, it may not require such a production. The court therefore seized upon the relevant lawful consent exception contained in the Stored Communications Act, and the court stated that a provider may divulge the contents of the communication with the lawful consent of the originator, an addressee, or the intended recipient of such communication. The court gave us key information in that case as to how to protect your digital assets and allow your fiduciary to obtain access to your digital assets. You should grant your fiduciary your lawful consent to allow the provider to divulge the contents of your electronic communications. Various states are attempting to pass laws and fill in the gaps created by the Computer Fraud and Abuse Act and the Stored Communications Act, and allow fiduciaries to access an individual's digital assets. Delaware was the first state to enact a law called the Fiduciary Access to Digital Assets and Digital Accounts Act. Your digital assets need to be protected, just like any of your other assets. If you would like assistance concerning how you can protect your digital assets, please feel free to contact our office. Thank you.